just in time for your most comprehensive weekly look at the world of business and economics. Welcome, this is Business Redefined. I am Julian Amboko, and tonight we are focusing on the pertinent subject of double taxation treaties. Double tax treaties are agreements reached between two jurisdictions, rather allocating tax rights and ensuring there is no imposition of tax on the same income by multiple jurisdictions. Such treaties seek to catalyze trade and investment flows between two jurisdictions. This notwithstanding, the treaties are open to manipulation through practices such as treaty shopping by briefcase companies. Kenya is presently pursuing double tax treaties with Singapore and Barbados. And tonight we take a deep dive into this with Alvin Mosioma, who is the Executive Director at the Tax Justice Network Africa, and Lena Onyango, who is an advocate and a specialist on tax matters. Welcome on set. And just to kick it off, Alvin, I was reading the Tax Justice Network analysis on this matter. The title is Trick or Treaty. Why is this the case?
Well, as you rightly said at the beginning, really the purpose of double tax agreement is to ensure that companies are not being taxed twice. On one side where they're registered and the other side where they're doing their business operations. But what our researchers have shown is that many a times these double tax agreements result to double non-taxation. So the companies find tricks to basically beat the system and shift profits away from the jurisdictions where they are operating. And therefore, we have been very critical about particularly the double tax agreements that are being negotiated and signed with the jurisdictions that are being considered as the tax havens.
All right. And crossing over to Lena, clearly there is an issue of merits and demerits here. From your assessment, what do you think outweighs the other in this case?
I'm looking from the whole idea of double tax treaties from a government and a private sector perspective is they avoid, as you have correctly defined it, they avoid instances where either a person is taxed twice or the same income is taxed twice in different jurisdictions. Now, the advantage, and I believe the whole intention of a double tax treaty is one, double tax treaties foster trade in between contracting states, which are the two-party states. Over and above fostering trade, they encourage foreign direct investment from a foreign jurisdiction into Kenya. Reason being, if they pump in money into the Kenyan economy, they will not be taxed both in Kenya and the jurisdiction of the residents of the holding company or their parent company. From a business perspective, I think double tax treaties open avenues that were probably not there, and it does not necessarily come across as for goods. It also cuts across the service sector. So double tax treaties are favorable and are actually a good move by the government in terms of trying to widen the tax treaty network in Kenya.
Okay. And before I bring in Alvin, I should say you can be part of this conversation by tweeting at NTV Kenya, at AmbokoJH, at Alvin Mosioma as well, just to give us your thoughts and to enable us to pick your conversation and share some of your questions to the panelists on this discussion. Coming back to you, Alvin, we have a precedent in this country where not too far back, the double taxation treaty with Mauritius was nullified by the High Court, thanks to your organization. Why is this the case? And are we in trouble again with what we are pursuing right now with Singapore and Barbados?
We are most likely to be in trouble, yes. The treaty the case that we filed in court against the Kenya-Mauritius double tax agreement was really built on two foundations. One, we were making an argument that the due process of the law was not followed. There's a very clear laid out procedures in terms of what governments should be doing when they are negotiating and signing double tax agreement. And some of these provisions, for example, in the new constitution says that Parliament needs to be involved in the ratification process. There should be measures for public participation. Government needs to ensure that they are conducting sufficient cost-benefit analysis to be able to argue and say, does this treaty with this particular country make sense? And in the case of Mauritius, we were convinced, and the court saw it right, that this was not the case. We were arguing, and indeed we were right, that the treaty with Mauritius was opening up the country for significant resource leakage, both through the different avenues, be it treaty shopping, transfer mispricing, round tripping, where you find Kenyan entities moving off to Mauritius to take advantage of particular provisions in that particular treaty. And in the case of Singapore and Barbados, we are very critical of this, and we have also made our submissions to the government, both on the technical part. But I also would like to add that we would like to commend the Kenyan government in terms of at least going its way in this particular treaty to consult the public. This is really, to my knowledge, the very first time that the government has taken the step to collect views from the public in terms of what do they feel about this particular treaty. But in essence, I think my really question is, why Barbados? I mean, a country which has got about 300,000 people, or why Singapore, which is ranked as number 6, one of the most secretive and one of the largest tax havens in the world? Why these particular jurisdictions, particularly in the context of Kenya committing to the African Free Trade Area? We should be looking at focusing at signing double tax agreement with the jurisdictions that we are actually doing business with, Uganda, the East African Community, and others. I think they should be having more priority than focusing on jurisdictions that are largely tax havens, which are, in my sense, are very open to abuse.
But Alvin, just to be fair to the government, and as I bring in Lena on this point, we might not know much about Barbados in terms of the trade volumes because of scarcity of data, but Singapore we do know. I mean, exports worth about 2 billion shillings, imports worth about 6.8 billion. Over the last 2 years, we've seen an increasing partnership between Kenya and Singapore in terms of data transfer as well as investment flows. Clearly, there seems to be a case here for an agreement with Singapore. Lena, what are your thoughts on this?
I agree with you on that. There has been substantial increase in investment from Singapore to Kenya. Personally aware of a company that is now doing affordable housing projects in Kenya. I think let's not paint DTAs to be a bad thing, in the sense that we cannot pick on a country like Barbados just by virtue of having a population of about 300,000 vis-a-vis the Kenyan population. But I believe in between Kenya and Barbados, there are certain trade activities. And correct me if I'm wrong, but I understand that the key intention of the government entering into the DTA with Barbados was to drive the financial services sector. And the government is really keen on having Kenyan financial institutions setting up and operating in Barbados. And that creates also bigger opportunities from a Kenyan perspective. So the DTAs do not only work against Kenya, but also look at it. I'm looking at it from the perspective that it has opened doors for Kenyan institutions to set up in other jurisdictions, and therefore we're growing our economy, and of course the Barbados economy benefits as well.
All right, and I'm sure, Alvin, you have a rebuttal to that. But even before we get into that, just to throw something at you, I was reading the critique of the Tax Justice Network Africa around this whole issue, and one of the issues you raised and recommendations really tabling is the matter of limitations of benefits, which, to the best of my understanding, if you read the Income Tax Act, Section 41, clearly spells out this issue. And if you consider that all these tax treaties are coming post January 2015, when the Income Tax Act came into force, don't you think this matter is addressed?
Okay, I'll speak to that later. Let me first address the question of investment through Singapore, the one you raised earlier about investment that are being channeled through Singapore and Mauritius. Really, what you notice that many of these jurisdictions that are considered tax havens have positioned themselves globally. They have designed their domestic tax laws deliberately as conduit hubs. So, in essence, what I'm saying is that it is not rich Barbadians that will be channeling their investment to Kenya. It's not Singaporean entities that will be channeling their investment in Kenya, but most likely you would find is Chinese investment, American investments, German investments, and we have seen there's evidence, for example, in the last expose of the Paradise Papers, where you found a treaty that had been signed between Senegal and Mauritius. Canadian companies were using that as an avenue to move to Mauritius, set up base there, and then come into Senegal as a Mauritian entity. And this is what we are seeing, and this is likely what's going to happen when you have these treaties being signed with these jurisdictions, that they themselves don't have substantive economic muscle, but are positioning themselves as conduit countries to channel investment. If you look at Mauritius, it is really marketing itself globally as the so-called gateway into the continent, which in my own sense is not really a gateway, but providing a getaway car for tax planning and tax avoidance particularly. To the second question you raised about limitation of benefits. In principle, yes, limitation of benefits can act as a very good instrument to be able to prevent tax abuse in a treaty network. But this only applies in cases where the substantive investment is coming from that particular jurisdiction. For example, if you were to have a situation where Kenya is signing a treaty with Germany and the investment are being channeled direct from Germany, as it were foreign direct investment coming directly from that particular country, then the limitations of benefit would work. But when you have situations where the treaty that is being negotiated and being signed is with a jurisdiction which is considered a tax haven, and we must note that tax havens really provide two things, Julian. Tax havens provide secrecy and they provide low taxation. They provide incentives that encourage companies to use those jurisdictions as conduits for channeling investment into other jurisdictions and taking advantage of the particular provisions of those double tax agreements. So in essence, we are not against double tax agreement per se. Actually, we have been campaigning and pushing for the Kenyan government to encourage the colleagues in Tanzania to sign the East Africa Double Tax Agreement. I think that in the context of the free trade area, the Africa trade area, we feel that the Kenyan government should encourage a broader treaty network because through it creates an enabling environment for investment. But we are critical of treaties that are being signed by jurisdictions that are considered tax havens. And this is the case with Singapore, and it's also the case with Barbados.
All right, and that point by Alvin takes us to a short break. We'll be right back with a lot more on this subject. Don't move too far.
Indigestion and heartburn? Eno gets to work in 6 seconds and works on the 6 symptoms of heartburn so you can keep living life non-stop. Eno, fight heartburn and indigestion fast.
I have to admit, I didn't like Sukuma Wiki when I was growing up, but now I've created a way to make Sukuma Wiki tastier and meatier. I simply add 2 Royco beef cubes, and the end result is a rich, meaty flavor. And today, I have brought along my harshest food critics for a taste test. My kids.
Lovely!
Royco beef cubes. Add 2 small cubes for a big, meaty taste.
with Sensodyne Rapid Action for clinically proven relief in 60 seconds.
May the chef who prepared 2020 please take it back to the kitchen. Throw 3 whole potatoes in it to suck the saltiness. Because dang, I don't care if we're halfway through it. This doesn't count. Tuseme basi tuko half time. Let's hashtag cancel 2020.
Are you a business owner? Sign up today to accept fast, easy, and secure payments through Visa. What's more, enjoy flexible financing options for your business. Call us today on 0703 095 445.
Welcome back to Business Redefined. Tonight we are focusing on the issue of double taxation treaties between Kenya and other jurisdictions, particularly the pursuit of such treaties with Singapore and Barbados. And of course on set I have Alvin Mosioma from the Tax Justice Network and Lena Onyango, who is a tax analyst and also legal professional focusing on this subject. Before the break we were discussing around a number of issues, including some of the challenges which are presented as well as opportunities. Lena, the issue of Singapore and Barbados being perceived as tax havens and could lead to revenue seepage. Many are curious to know to what degree would the Foreign Account Tax Compliance Act, which has been enforced in the United States, play a role in terms of disclosure of some of these ventures where, of course, a lot of concern is coming from in terms of what could this translate to a country like Kenya?
The FATCA, which is the U.S. mechanism for getting financial information about his residents in other jurisdictions, it is similar to the EU savings rate. They call it the EU STD, and Kenya signed up to the automatic exchange of information, a project that has been driven by the OECD and the G20. Basically, the effect of this would mean that information between different countries, financial information between different countries, will now be automatically exchanged annually between the revenue authorities. If you look at the double tax treaties for both Barbados and Singapore, they provide for exchange of information. But now, with Kenya being a signatory to the automatic exchange information mechanism, then that means that if there is any person who sort of moves money from Kenya to a financial institution, which could be a bank or a broker, either in Singapore or Barbados, then that information will be relayed to the KRA, and they will therefore be able to compare what declaration the taxpayer has made in Kenya vis-a-vis the information that they have obtained, and will be able to carry out investigations on that. So I'm not really worried about the DTA between Singapore and Barbados insofar as illicit financial flows is concerned. Reason being, there are over and above them big signatories to the automatic exchange of information. It is required for companies that have cross-border transactions, meaning a Kenyan company trading with a Singaporean company or a company based in Barbados will have a transfer pricing policy. A policy that KRA approves, a policy that is shared with KRA, and this ensures that whatever intercompany transactions, the price at which those transactions are charged, then they have to be at an arm's length, meaning they have to be reasonably priced. And I believe Alvin can confirm this, that the way that the illicit financial flows, about 80% of it is through transfer mispricing. So I feel as a country, if we only get sort of tap into the whole concept of transfer pricing legislation, which is there,
okay, but
also into automatic exchange of information, then we should be able. I don't think we should be worried about the issue of illicit profit transfers from Kenya.
All right, Alvin, I mean, clearly, Lena and I seem to be on the same page. We don't seem to be too much bothered as far as this issue of illicit flows is concerned, given the provisions of FATCA. Yeah. What's your take on this matter?
Well, I agree with Lena that transfer mispricing, as it were, is the largest avenue for resource leakage for what the phenomena of illicit financial flows. And really, what we notice that countries either don't have the capacity across the continent, or they don't have sufficient laws in place to be able to address the challenges that are related to transfer mispricing. But more above that, really, if you look at the concept of transfer pricing, today we live in a world where over 80% of transactions through intellectual property, through online transactions, the Ubers, the $2 trillion Amazon, which is really doing transactions online. And here, the question of transfer pricing becomes really difficult to tackle because there's no really market value for particular services. There's no particular brand values. What is the price of what's the Google as a product, as the brand of Google? What's the market value of that? So it becomes really difficult to tackle that question of transfer mispricing because of the global shift we are seeing towards trading services as opposed to trading goods. On the question of automatic exchange of information, here I would like to differ because what you note really that the framework of automatic exchange of information was set up to really tackle tax evasion. And even in terms of how it is framed, if you look at the founding documents, they are talking about tax jurisdictions, tax administration exchanging information to be able to fight the illegal tax evasion. Tax avoidance, I don't believe that automatic exchange of information is the appropriate tool to address this kind of profit shifting. Okay. Here, I would recommend the country-by-country reporting, which I think has been a provision that has been, again, the conversation has started under the OECD. But what we see is that the thresholds that have been put for companies to be able to report on a country-by-country basis are too high to be useful for developing countries, particularly, and more importantly for African countries. Okay. So I think that the double tax agreement, yes, there are those automatic exchange of information, there are transfer pricing regulations that are being put in place, but I still believe that the loopholes that they open are really significant, and in the effort for countries to generate more revenue, these double tax agreements are more good than they are good. They are more bad than good for the country.
Still within the context of exchange of information and of course the transparency within which this will take place, Lena, looking at this within the context of the Convention on Mutual Administrative Assistance Agreement, did you feel we have another safeguard as far as that is concerned regarding the concerns being raised by Alvin?
I think you cannot take a one-way approach. We have the DTAs, we have the transfer pricing guidelines in Kenya, which are enforced in Kenya. Kenya, over and above that, Kenya has signed up to the automatic exchange information, which now, of course, the common reporting standards and the whole OECD framework around it. But if you also look at the development in terms of legislation, now the commissioner has a right, if he feels that a taxpayer has just made an arrangement for purposes of avoiding tax, then the penalties are double the tax that would otherwise have been paid. So even on a domestic front, there are those punitive measures that have now been put in place to discourage this kind of arrangements. And just to build up on that, the reason why I believe that provision was sort of put, it is not a blanket provision that, now if the commissioner feels Amboko has probably shifted 100 million to Barbados, then you're supposed to pay double the tax. But what was the intention? What was the commercial benefit that you were thinking or that you wanted to obtain by investing in that other country? And that is also, from those of us in the legal front, we have noticed a shift in decisions of the court, especially in the UK, that over and above the fact that avoidance is legal, it is not illegal, but tax avoidance is legal, but it becomes an abuse of treaty if you plan your affairs without a commercial perspective or without having a commercial justification for it. So there is definitely need for commercial justification when taxpayers are making this kind of arrangements.
All right, Lena, the hypothetical case you've given of Amboko shifting 100 million shillings, how I wish I had that sort of liquidity with me. There's a gentleman, Alvin, asking that Alvin has evaded the question on the limitations of benefits. It applies to all transactions in a DTA irrespective of FDI coming in or not. What's your take on this, Alvin?
So, as I said earlier, limitations of benefit provisions are effective in situations where the investments are directly coming from the country of origin, the country where those investments are coming from, not a conduit country. Okay. In situations where, as I said earlier, with particularly with tax havens, what you find is that the investments are channeled from country A through country B before they land in country C. and that we have seen, as I gave an example of the Paradise Papers of mining companies. We had the case even in Uganda of an oil company that was using Mauritius as a conduit to invest into Uganda when actually the company came from the UK. So in situations like that, when you find that the domestic law of these tax havens is designed in a way that it encourages companies from the investing countries to use them as a conduit to invest in other countries. So because of that, the limitations of benefit becomes really ineffective in my own opinion. Okay, I have just about a minute to go. Lena, very quickly, your closing remarks.
Just to close, Amboko, first of all, thank you for this opportunity. I'm really happy that as a country we're having this conversation. I feel that there is not much awareness around the effect of double tax agreements. And as Alvin has stated, the whole idea of public participation should not just be limited to stakeholders. Parliament should also be involved. Members of the public should also be more proactive, because these are decisions and these are agreements that are going to have an impact on them one way or the other. So my parting short is just to say I feel Kenyans need to be more proactive on some of these things. And with the Tax Justice Network and the KRA, I feel a lot of awareness needs to be raised over the impact of such kind of agreements in Kenya.
Alvin, very briefly, your closing remarks.
I fully agree with the final remarks from Lena. I think that there's really need for more public participation in this process, because ultimately it is about where the money that is financing development is going to come from. And what we see across Africa, and even in the case of Kenya, is that there's a huge shift of the taxation burden to the low income earners, while those that in the top categories are getting away with it, because they have found ways of playing with the law and finding loopholes, particularly in the double tax agreement, to shift their profits and minimize their tax obligations. And this is for this reason that we feel that public participation in the tax formulation process is very instrumental. And that's the work that Tax Justice Network Africa was established to do.
All right, and those comments by Alvin take us to the close of Business Redefined. This week we've been focusing on the double taxation treaties. Let's do this again next week, same place, same time. I will leave you with the markets report.
They're brought to you by Business Daily. More possibilities.
Thank you.
Thank you very much.
Thank you.